So there are some concurrences and one dissent to this gun opinion, major gun opinion from the Supreme Court, major Second Amendment opinion. Again, 6-3, Justice Thomas writing for the court, striking down New York's law that is a may issue law, basically saying that you have to demonstrate some sort of special need in order to get a carry permit. Justice Alito has a concurrence. He points out much of the dissent seems designed to obscure the specific question this court has decided, and therefore it might be helpful to provide a succinct summary of what we've actually held. In D.C. versus Heller, the court concluded the Second Amendment protects the right to keep a handgun in the home for self-defense. Although Heller concerned the possession of a handgun in the home, the key point we decided was the people, not just members of the militia, have a right to use firearms to defend themselves. And because many people face a serious risk of lethal violence when they venture outside their homes, the Second Amendment was understood at the time of adoption to apply under those circumstances. The court's exhaustive historical survey establishes that point very clearly. Today's decision holds a state may not enforce a law, like New York's Sullivan Law, that effectively prevents its law-abiding residents from carrying a gun for that purpose. That is all we decide. Our holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun, nor does it decide anything about the kinds of weapons people may possess. We haven't disturbed anything we said in Heller versus D.C. So the dissent, as we will get to in just a second, it is completely designed to obscure the constitutional question at all. And so Alito basically just slams the dissent for doing that. He says, Heller correctly recognized the Second Amendment codifies the right of ordinary law-abiding Americans to protect themselves from lethal violence by possessing and, if necessary, using a gun. In 1791, when the Second Amendment was adopted, there were no police departments. Many families lived alone on isolated farms or on the frontiers. If these people were attacked, they were on their own. It's hard to imagine the furor that would have erupted if the federal government and states had tried to take away the guns these people needed for protection. Today, unfortunately, many Americans have good reason to fear they will be victimized if they are unable to protect themselves. Today, no less than in 1791, the Second Amendment guarantees their right to do so. Justice Kavanaugh also has a concurrence, joined by Chief Justice Roberts, to underscore a couple of points. He says, first, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the existing licensing regimes employed in 43 current states. It's only talking about may issues. So it's possible that they can still have licensing requirements. You can undergo, for example, fingerprinting, a background check, mental health records check, training in firearms handling. Like all of that is still legal. Like states can still do that. It's just saying that you can't have an arbitrary and capricious standard effectively for denying people their Second Amendment rights. Second, says Kavanaugh, as Heller and McDonald established, and the court today again explains, the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Properly interpreted, the Second Amendment allows a variety of gun regulations. Justice Barrett has her own concurrence. She says she wants to point out a couple of things. First, the court does not conclusively determine the manner and circumstances in which post-ratification practice may bear on the original meaning of the Constitution. Scholars have proposed competing and potentially conflicting frameworks for this analysis, including liquidation, tradition, and precedent. The limits on the permissible use of history may vary between these frameworks. To name just a few unsettled questions: how long after ratification may subsequent practice illuminate original public meaning? What form must practice take to carry weight in constitutional analysis? May practice settle the meaning of individual rights as well as structural provisions? The historical inquiry presented in this case does not require us to answer such questions, which might make a difference in another case. So this is her attempting to basically say that while this particular case does originalism properly, we might not always do originalism properly. That's really what Barrett is saying. And I think the reason she's saying that is because what she's attempting to end around here is the fact that according to the original interpretation of the Constitution, there are a wide variety of cases that are well settled in American law that probably are not with the original interpretation of the Constitution, but the court ain't going to touch it. That's what she's saying here. Secondly, and relatedly, says Barrett, the court avoids another ongoing scholarly debate on whether the court should primarily rely on the prevailing understanding of an individual right when the 14th Amendment was ratified in 1868 or when the Bill of Rights was ratified in 1791. Today's decision should not be understood to endorse freewheeling reliance on historical practice from the mid to late 19th century to establish the original meaning of the Bill of Rights. Okay, now we get to the dissent. And the dissent just shows you how constitutional interpretation is done by the left. And you see it, by the way, in some of the comments from my friend Piers Morgan. So Piers Morgan, who he and I have been going at it over gun rights for a very long time. Piers Morgan, he tweeted out in the immediate aftermath of this ruling, breaking, America's response to its recent mass shootings is to make it even easier for Americans to use guns. The Second Amendment is now being interpreted as a right to bear arms as part of an unregulated civilian militia. And I responded, that's not a response to mass shootings. That's what the Constitution says. And then he responded, do you agree with the Supreme Court ruling? Do you feel this is the right way for America to go? Well, it's not a question of policy. It's a question of constitutional interpretation. The court does not have the same job as the legislature. And this is where we run into the interpretation of the Constitution by the left more generally. If the left has its way, as it's funny to watch people like Noah Smith, who is a writer from Bloomberg, suddenly realize, wait a second, you mean that the left wing of the court has been writing public policy for years? Yes, that's what we mean. The way that the left interprets the Constitution is whatever I feel like today. So if I don't like mass shootings, I'm just going to rule the Second Amendment doesn't apply, ever. And that's basically what the dissent does in a very lengthy dissent. So here's what Justice Breyer, writing the dissent, joined by Sotomayor and Kagan, write. In 2020, 45,222 Americans were killed by firearms. This is how they open. And the question is, and? That's like citing a free speech opinion by saying, in 2020, several million Americans were deeply offended by commentary under the First Amendment. That doesn't solve the question as to whether the commentary is protected by the First Amendment. And the number of Americans hurt by firearms does not actually solve the question as to what the Second Amendment covers. They continue, many states have tried to address some of the dangers of gun violence just described by passing laws that limit in various ways who may purchase, carry, or use firearms of different kinds. The court today severely burdens states' efforts to do so. It invokes the Second Amendment to strike down a New York law regulating the public carriage of concealed handguns. In my view, that decision rests upon several serious mistakes. First, the court decides this case on the basis of pleadings without the benefit of discovery or an evidentiary record. As a result, it may well rest its decisions on a mistaken understanding of how New York's law operates in practice. No, you don't actually need a discovery in order to determine that you can't set up an arbitrary standard, a vague and arbitrary standard for denying people their ability to bear arms. Second, says the left wing of the court wrongly limits its analysis to focus nearly exclusively on history. It refuses to consider the government interests that justify a challenged gun regulation, regardless of how compelling those interests may be. The Constitution contains no such limitation, neither do our precedents. Well, hold up. Again, name another amendment to the Constitution other than the second, where the left says, well, it's perfectly legal for you to say X, but there's a compelling state interest in shutting it down. You really, like, where? That has never been the standard for a constitutional violation. Again, I'll take the First Amendment because it's the one that everybody knows the best. Let's say that somebody says the N-word. Pretty compelling interest the government has in prohibiting people from saying the N-word. It's a really ugly word. It's likely to lead to people engaging in violence. But if there were a regulation that said, you are not allowed to say the N-word, and if you do, we'll throw you in jail, that would be struck down on First Amendment grounds. Compelling government interest doesn't come into it. It's only when it comes to the Second Amendment that the left wing of the court wishes to apply the standard. Third, says the left wing of the court, Breyer, joined by Sotomayor and Kagan, the court itself demonstrates the practical problems with its history-only approach. In applying that approach to New York's law, the court fails to correctly and identify the relevant historical facts. Only by ignoring an abundance of historical evidence supporting regulations restricting the public's carriage of firearms can the court conclude that New York's law is not consistent with the nation's historical tradition of firearms regulation. So basically, they're saying you can never look back at a law from 1903 and say that it is not in our nation's tradition, even if it was well out of step with 1791 law. Well, or you can. And the left has a very malleable view of precedent. The court will suggest that precedent of 200 years ought to be overturned because things changed today, but you can't overturn a precedent from 1903 because now it's historical precedent. So again, what it really comes down to for the left when it comes to constitutional interpretation is what do we wish would happen? And a huge swath of their opinion revolves around all of the evils of gun violence. And as Alito points out, that has nothing to do with the constitutional question. Well, here is how Breyer responds to that. He says, Justice Alito asks why I've begun my opinion by reviewing some of the dangers and challenges posed by gun violence and what relevance that has to today's case. All of the above considerations illustrate that the question of firearm regulation presents a complex problem, one that should be solved by legislatures rather than courts. Name a problem that's not complex in American law. Seriously, that's not complex. Because by that rubric, there is no such thing as a constitutional protection. And that's the thing. When it comes to the left, constitutional protections exist where they don't exist and don't exist where they should exist. And that's what you see from this Breyer dissent. Look, if Donald Trump deserves credit for anything. He deserves credit for more conservative justices being on the Supreme Court, because there is no question that if Hillary Clinton is elected president, this case goes the other way. And if this case goes the other way, the Second Amendment ends up gutted. Okay, so Justice Breyer's dissent concludes by basically suggesting the historical analysis done by the court is wrong. And then Breyer says, we're bound by Heller insofar as Heller interpreted the Second Amendment to protect an individual's right to possess a firearm for self-defense. But Heller recognized that right was not without limits and could appropriately be subject to government regulation. Heller therefore does not require holding that New York's law violates the Second Amendment. In so holding, the court goes beyond Heller. Well, it's always sort of fascinating when you see the people who actually dissented in a case trying to argue what that case meant. It is worthwhile going back and looking at how Heller came down. You will realize that the majority opinion in Heller was delivered by Scalia, joined by Roberts, Kennedy, Thomas, and Alito. Breyer dissented in that case, and now he's telling you what that case meant. No. So, says Breyer, it bases its decision to strike down New York's law almost exclusively on its application of what it calls historical analogical reasoning. As I have admitted above, I'm not a historian, neither is the court. The history, as it appears to me, seems to establish a robust tradition of regulations restricting public carriage of concealed firearms. To the extent that any uncertainty remains between the court's view of the history and mine, that uncertainty counsels against relying on history alone. In my view, it is appropriate in such circumstances to look beyond the history and engage in what the court calls means-end scrutiny. Ah, how convenient. We're not historians. We don't know history. We don't know what words mean. So why don't we just engage in what we think is best public policy? Means-end scrutiny is what we just call the job of a legislature normally. I mean, it's, again, very odd how he wishes to completely discard the role of a judge in favor of the role of a legislature, which is, again, the common theme here. Courts must be permitted to consider the state's interest in preventing gun violence, the effectiveness of the contested law in achieving that interest, the degree to which the law burdens the Second Amendment right, and, if appropriate, any less restrictive alternatives. The Second Circuit has previously done just that. It held New York's law does not violate the Second Amendment. It first evaluated the degree to which the law burdens the Second Amendment right to bear arms. It concluded the law places substantial limits on the ability of law-abiding citizens to possess firearms for self-defense in public, but doesn't burden the right to possess a firearm in the home. Well, yes, but since when does why does self-defense apply only in the home? The Second Circuit therefore determined the law should be subject to heightened scrutiny, but not strict scrutiny, and its attendant presumption of unconstitutionality. Understand, by the way, the first rule in constitutional interpretation is the Constitution doesn't matter, at least according to the left. The words strict scrutiny, intermediate scrutiny, and rational basis review appear nowhere in the actual Constitution of the United States. They do not, they are made up standards by people like Justice Breyer in order to essentially justify them doing public policy. And this is the fundamental point that the left seems not to understand. The job of public policy is for a legislature. The job of Supreme Court decision-making is for a Supreme Court. And so long as you conflate the two, the Supreme Court just ends up as a super legislature doing the work of Democrats. That's what the court said today. The court said, or that's what the court has said. The court now says, no, that is not the way any of this is going to work. The Second Amendment prohibits a thing. You don't like it? Change the Second Amendment. Breyer concludes his dissent by saying New York's legislature considered the empirical evidence about gun violence and adopted a reasonable licensing law to regulate the concealed carriage of handguns in order to keep the people of New York safe. The court today strikes down that law based only on the pleadings. It gives the state no opportunity to present evidence justifying its reasons for adopting the law or showing how the law actually operates in practice. It does not do so as much. It does not so much as acknowledge these important considerations. I cannot agree with the court's decision to strike New York's law down without allowing for discovery or the development of any evidentiary record, without considering the state's compelling interest in preventing gun violence. Again, I will never understand why left-wing legal scholars believe that their job is to be the legislature. It's beyond me. What do you think, why do you have a special job with lifetime tenure if your only job is just to be a Democratic senator from the state of New York? But apparently that is what a lot of people think. And now they're looking forward to blaming the Supreme Court for gun violence. So first of all, as noted by several of the concurrences, nothing in the opinion bars people in the states from creating license requirements for concealed carry. You can create those license requirements. They just have to be objective. The big issue with New York and California and DC and all the rest of these left-wing jurisdictions is that they are deliberately intended not to be objective. That is their goal. That is their specific goal. The left, of course, can't handle this. The left is going nuts over all of this. So you have a wide variety of people on the left losing their minds. The White House immediately released a response. New York Governor Kathy Hochul immediately responded. She said, shocking, absolutely shocking, that they've taken away our right to have reasonable restrictions. We can have restrictions on speech, but somehow there's no restrictions on the Second Amendment. She doesn't know anything about con law. She just doesn't. What restrictions on speech are allowed? Like, well, what would be the analogous restriction on speech she's referring to? It doesn't exist. Like, where is she getting this? Meanwhile, you have legal analysts like Paul Waldman, opinion writer at the Washington Post, saying, just getting started reading the gun decision, every sentence so far makes clear what a joke and a scam originalism is. It continues to amaze me anyone takes it seriously. No, we should probably take more seriously a bunch of left-wing justices just doing whatever they want and then bull crapping about how it's in the Constitution. That's how we got a right to abortion. Meanwhile, the inestimably stupid Keith Olbermann tweeted, it has become necessary to dissolve the Supreme Court of the United States. The first step is for a state the court has now forced guns upon to ignore this ruling. Great, you're a court. Why and how do you think you can enforce your rulings? Good luck with that. Again, it is the outrage, the pure, abiding outrage is amazing. They do not understand what courts do around here. They don't understand. Again, Alito just shreds Breyer. He says, what is the relevance of statistics about the use of guns to commit suicide? Does the dissent think that a lot of people who possess guns in their homes will be stopped or deterred from shooting themselves if they cannot lawfully take them outside? This is true. Breyer actually says that in his dissent. He's like, I'm going to cite a bunch of bad gun stats. And among those bad gun stats are how many people commit suicide. Well, most people commit suicide in their homes. That's already protected by DC versus Heller. Right? Alito says the dissent cites statistics on children and adolescents killed by guns. What does this have to do with the question of whether an adult who is licensed to possess a handgun may be prohibited from carrying it outside the home? Our decision does not expand the categories of people who may lawfully possess a gun. Federal law forbids the possession of a handgun by a person under the age of 18 and bars the sale of a handgun to anyone under the age of 21. The dissent cites the large number of guns in private hands, nearly 400 million, but it doesn't explain what that stat has to do with the question whether a person who already has the right to keep a gun in the home for self-defense is likely to be deterred from acquiring a gun by knowledge that the gun can't be carried outside the home. No one apparently knows how many of the 400 million privately held guns are in the hands of criminals. There can be little doubt many muggers and rapists are armed and are undeterred by the Sullivan Law. So again, the logic that is being presented by the left is basically scream at the moon. Well, that is not constitutional jurisprudence. And it is always amusing to watch as the left begins to realize the Supreme Court is not just a magical legislature that does their most deeply held bidding, which is what they wish it were, and which is what it was when the left was fully in charge of the court. Look, Alexander Hamilton said it best in Federalist 78, if the court were to just become an instrument for the institution of the will of one particular side without reference to the text and history of the Constitution, it will lose its reason to exist. And what we have found is that the court finally, for the first time in my lifetime, has begun to actually treat itself as a court that interprets the text of the Constitution rather than as a super legislature to do the work of militant Democrats. That is a good thing. That will restore faith in the court, because when the court is ultra-crepidarian, when it gets involved in tasks beyond its purview, it means that people do not wish to listen to the court. People begin to stop listening to the court because they feel, why would we have a bunch of robed, unelected, lifetime appointed judges deciding our most fundamental rights based on whatever is in their head, rather than in the Constitution of the United States, the governing document of the country? Did you know that every single like creates one additional leftist tier? That is just science.